for graduates might at this moment find it difficult because you may not already have a job offer. But I think it is very important to know that this is a very good opportunity for yourself. Because if I were still have to choose, I would still have become a barrister.
How to fail big as an instructing solicitor and give your counsel high blood pressure and heart attack.
How to fail big as an instructing solicitor. As I see it, one primary point is unreliability. If I ask for something to be done, or if I ask him to ensure XYZ, or to ensure his client knows XYZ, and he doesn't do it, then that is a big failure, because the conduct of my case would depend on him as a channel of communication, and that has better be a very reliable channel of communication, because we don't talk to the client directly, and we are not locked in a room with the client and the solicitor all the time. So on the eve of a case going to court, it is always like pandemonium. I mean, there are so many things to deal with, and there are so many things that you need to communicate to the client or to the witness, and you have to do it through the solicitor, and the solicitors must not fail. Secondly is poor discipline in managing the logistics, particularly in court cases. If the solicitor is the party filing the papers, the solicitor role is very important. I mean, you may think that it's like, which doesn't require a lot of intelligence or a lot of brain work, but actually, if the papers are organized very well, then it could only work for parties, because the judge will find it easy to follow. And if there is failure in that regard, then I would call it a very big failure in the litigation context. The third point I would raise is that it would be a big failure if you are if counsel, a barrister, is in the driving seat and the solicitor goes behind her back to take certain steps, for example, maybe communicating to the other side or communicating with the court on certain things without letting the barrister know. I think it's a big failure if the litigation in such a stage that the barrister is in the driving seat. Then the barrister will need to know everything that's happening around the litigation, and the solicitor really should give the barrister full information. And what I have experienced is some solicitors think that, well, I mean, these things I don't want you to know, because if I let you know, it might affect how much effort you put into the preparation, for example. Or he might think that it's such a small thing that he doesn't need to let the barrister know, and he would do this clever thing behind her back and then hoping to do something for the client. Sometimes it doesn't matter, but other times it could damage the case because it may not sit well with the way in which counsel was intending to run the case. So I would call that a big fail as well. But the ultimate failure is to lose the trust of the client. And I think the solicitor loses his trust with the client by picking the wrong barrister. So the big fail of a solicitor is in identifying the best person for the job. I still see surprising choices from time to time. And then you have solicitor instructing somebody who doesn't know the first thing about the area of the law. And you would have thought that, oh my God, and this is a big fail to the client, because the client is the source of the work. And if the client is lost, then the work for the barrister is lost as well.
You can build in one of compassion, creativity, or sense of humor to the AI judge. Which one will you pick?
I think without any doubt, out of the three qualities of compassion, creativity, and sense of humor, it would be compassion. Sense of humor is something that keeps the judge alive, but the AI judge has no real life. I mean, it's a machine, so it doesn't matter. He won't go into depression, hopefully, without sense of humor. As barristers or as lawyers working in the same courtroom with the judge, we will never depend on the judge's sense of humor to survive. In fact, a judge's sense of humor will send out wrong signals and sometimes give you wrong ideas about what the judges was thinking, really. So I actually would rather have judges without that sense of humor, but certainly not grumpy judges. And then I think creativity is very good, but if a judge is very creative in himself, it is very dangerous for the advocates, because he might go off on a tangent of his own without you having a chance to actually deal with what he was really thinking. Now, a judge seldom researches deeply into a particular issue arising in a case by himself, because that is really the work of counsel. If counsel has done the research thoroughly and presents a point of view, and the other counsel presents a different point of view, it is up to him to tell counsel what troubles him and who he agrees with. If he agrees with neither, then he might, if he has the time and the stamina, to go into research himself. But I don't see that happening very often. I mean, these days, in the Court of Appeal, the Court of Appeal judges could ask judicial assistants to do the research for them. But I think if the decision is based on research, then one is not too worried. But if it's based on creativity, with no firm and sufficient legal basis, then that would be a very dangerous thing for the development of the law as a whole. So out of the three qualities, I think compassion is the most important, because it is very important not only for the advocate to be empathetic, to be able to see things from the client's point of view. It is also very important for the judge to be able to see what underlies the legal aspect of things. Well, in criminal cases and in family disputes, in family cases, this is particularly useful, I think, because within the width of his discretion, and the judge, when he makes a decision on whether sentencing or how to deal with issues in the family, like children, or how to deal with property, there is a breadth in the discretion that he could choose to exercise in. So he could decide to inject compassion into his decision and temper it with a complete understanding, a deeper understanding of the difficulties faced by each party in a family case, for example, and the difficulties faced by the accused. And he also must understand the difficulty faced by the party, say the police, in arresting the accused in the circumstances, for example. And then he would be able to arrive at a much more sensible decision. So I think compassion is important, and a fair-mindedness is, of course, most important. So a fair-mindedness is the pillar of the qualities of a judge, and then compassion is a quality that can temper this pillar of quality, fair-mindedness.